Members, we have a quorum. So I call this meeting to order. The first item on the agenda is to elect a deputy chair. Appendix 4 of the House Rules have set out the procedures for the election of the deputy chair for the Bills Committee. This is the meeting of the Bills Committee on Registration of Titles and Land Miscellaneous Amendments Bill 2025, and we're proceeding to electing a deputy chair. The Secretariat already issued a notice to members. At the close of the nomination period, we received one valid nomination, and that is Ms. Doreen Kong, nominated by myself and seconded by Mr. Andrew Lam in accordance to paragraph 8 of Appendix 4 of the House Rules. Members may decide whether to elect a deputy chair on receiving a valid nomination. So members, do we agree to elect a deputy chair? The answer is yes. So I declare that Ms. Doreen Kong is elected deputy chair of the Bills Committee on Registration of Titles and Land Miscellaneous Amendments Bill 2025. Let's invite the administration to come in.
好，咁或者喺咧官員進入緊嚟嘅時候。
While the administration is coming in, let me read out the attendance lists. We're joined by Secretary for Development, Ms. Bernadette Lin, Ms. Doris Ho, Permanent Secretary for Development Planning and Lands, Mrs. Elena Chan, Deputy Secretary for Development Planning and Lands, and Ms. Cheng Hoi Shan, Principal Assistant Secretary for Development Planning and Lands, Ms. Joyce Tam, Land Registrar, Mr. Eric Lee, Deputy Principal Solicitor, Lands Registry, Mr. Anderson Chan, Senior Government Counsel from the Department of Justice, and also Ms. Eunice Wong, Government Counsel. So let me welcome the administration to our meeting. I will invite the administration to, first of all, walk us through the registration of titles and land miscellaneous amendments Bill 2025. They will do so with the aid of a PowerPoint. And members, if you're interested to ask questions, please press the button now. I'll give the floor to the Secretary. Thank you, Chair. Since this is the first meeting of the Bills Committee, I will first explain the philosophy and the framework behind this bill titled Registration of Titles and Land Miscellaneous Amendments Bill 2025. We're going to introduce for the new land, and I will explain what new land means in a moment, the title registration regime. This marks a very important step towards the introduction of a title registration mechanism for Hong Kong. It is very important because over the years we have been practicing another registration system called the deeds registration system. Only a few jurisdictions around the world still run a deeds registration system. The deeds registration system gives no guarantee of title to the property. So when properties are assigned, it is necessary to go through the historical title documents to ensure the title is good, and that causes the conveyancing procedures to be cumbersome. And the owners are required to keep properly all the title documents. In fact, the Land Titles Ordinance LTO or CAP 585 was enacted in 2004 to put in place a title registration system which would replace the deeds registration system. This would bring Hong Kong on a par with other jurisdictions. Well, despite the ordinance being enacted, we failed to reach a consensus with stakeholders on implementation details. For example, the conversion arrangements for titles under the deeds registration system to be converted to a title under the title registration system. So in order to implement a regime that works, we believe that we should go for the easier steps first, and that means we take a new land first proposal and deal with the conversion of existing land at a subsequent stage. The land registrar will brief members on the major legislative proposals in this bill. These principles are supported by some fundamental policy considerations, and I will go through them with members. The objective of a title registration system is to provide title certainty. The title register will become conclusive evidence of indefeasible title. That means the title ownership is as plainly set out in the title register. So following the practice in other jurisdictions, after introducing the title registration system for a bona fide and innocent purchaser who has acquired property for value consideration and in possession of the property. Now, if subsequently acts of fraud on the part of a third party is found to be involved, this owner will still have indefeasible title. This is the fundamental principle underpinning the title registration system. And on the same consideration, after implementing the title registration system, no claim for title ownership can be made in the future. That it is in relation to adverse possession of the title. And as I mentioned, if a fraudulent third party is involved, that means inevitably the innocent former owner will be involved as well. We propose to set up an indemnity fund for the former innocent owner. This is called the Land Title Indemnity Fund, and this is in line with the practice in other jurisdictions. This indemnity fund will operate on a user-pay principle and self-sustaining basis. A levy will be charged for assignments in order to support the fund. But I need to emphasize that levy will only be imposed on transactions or assignments of titles under the title registration system, and only new land will be covered. Now, there are anti-fraudulent measures. The land registrar will further explain them to you in a moment. As we want to make a start, we would like to work on the easier segments first. So when will the system apply to existing land? Our thinking is that after implementing the title registration system, we can acquire experience, and then we can evaluate the situation and further expand the arrangement to cover existing land as well. But we're not just stopping at the initial stage. We're getting ready, and that means we're conducting a study. We are at the moment conducting internal research in relation to the 2.9 million titles or registered deeds with problems or default or faults, and we have consulted various stakeholders, including the banking sector, property development sector, in December 2022 and January 2025. On 2 occasions, we consulted the panel on development of the council as well. We had the members' general support, so we will work full steam for passage of the bill within this legislative term. Subject to passage of the bill as scheduled, we will also table into the Council subsidiary legislation next year. Coupled with publicity, we strive to pass the subsidiary legislation so that the ordinance can take effect in 2027. Now, I will give the floor to the registrar to explain details of the bill, and then we will also explain the specific provisions during the clause-by-clause stage. Thank you. I will spend about 20 minutes to explain the amendment bill. The amendment bill is divided into 4 parts. The first part is preliminary. Second, amendments to Land Titles Ordinance, covering 104 clauses divided into 14 parts and 4 schedules. There will also be corresponding and consequential amendments to 70 pieces of legislation. Part 3 is amendments to the land title ordinance. Part 4 relates to the land registry trading fund, and I will first explain part 2, which is the biggest portion of the bill. There are 14 parts to the land titles ordinance enacted in 2004. I will be explaining the 5 major parts, and they can be found in the 14 parts in the LTO. The first part relates to the implementation of the new land first proposal as explained by the Secretary. We are going to provide a new definition for new land, and that is for land lease that takes effect after the commencement dates of this bill. They will be regarded as new land. Now, generally speaking, they include land granted in the following 3 ways: by way of land sale, by private treaty grant, and by land exchange. We don't propose major changes to this definition in the amendment bill, but we also provide for exceptions. For example, for land let out by the government through a short-term tenancy, they are not regarded as new land. And according to the another exception, that is land lease granted before the operation date, they are not covered by the scope of new land. The amended LTO will only apply to new land. There will also be some provisions related to land that will be deleted or revised. For building on straddled land, that means straddled between a piece of land before the commencement date and the one after the commencement date. It will not be disposed of in the same way, and it will not be registered as undivided shares, etc. That means for new building developed on straddling land, it will be regulated under both the land title system and the deeds registration system. Then different legal principles apply, and that will cause uncertainty and complexity in terms of title ownership. The second proposal is to enhance title certainty. The conclusive evidence of title is the title register, and that means only when there are overriding interest or ratification orders imposed by the court will the registered title owner be bound. In other words, there is no need to check the deed documents to confirm title ownership. Overriding interest refers to lease not exceeding 3 years or reasonable public interest. Adverse possession under the current system amounts to overriding interest. But we must make sure that under the new Land First proposal, adverse possession will not be binding on the owner, and that is why we will remove the adverse possession mechanism and will also amend the limitation ordinance to reflect the change.
And
the third principle is the implementation of the principle of indefeasible title. There is the mandatory rectification principle. In practice, well, the ex-owner of the property can go to the court to make an application in order to restore his or her title rights. This is to reflect the position of the common law system, the land registration system under the common law system. If the mandatory rectification principle is a basic rule which must be complied with, then all buyers will check the history of the property. It seems to run counter to the mandatory rectification rule. That's why we propose to delete the provisions in relation to mandatory rectification. We will add new provisions for bona fide buyers. The court will not make an order to update or to rectify the title registration record. It means the buyer will enjoy indefeasible title. Then the ex-owner may enjoy an indemnity with a cap. In relation to the possession of property, it means tenants, trustees, beneficiaries of the trust, mortgagee, and licensee, they are considered to be in possession of property. The fourth legislative proposal is to improve the arrangements for rectification and indemnity. Under the title ordinance, the land registrar can make a ratification, and the court can make a rectification in the land register record as well. In the event of many mistake or missing information, if the registrar is convinced that the update will not cause any material impact on the benefits and interest of the owner of the registered title, then the registrar can make a rectification accordingly. Say, for example, a misspelling, the land registrar can rectify the mistake. As for the court, in case of any mistake, missing information, fraud, invalid instrument, the court can make an order to rectify the land registrar or the title registrar. In relation to the mandatory rectification, we will delete the relevant provisions. In relation to the time bar, anyone making an application to the court to update the title register, say for fraud or the omission, then within 12 years, one can make an application to update the title register. Under the LTO, we will set up the Land Titles Indemnity Fund. We will adopt a principle of users pay and self-sustaining. We recommend the conveyancing. The levy rate should be 0.017% of the cost of conveyancing with a cap of $5,000, and that is back in 2004. And our proposal is to change the percentage to 0.014% with a cap of $7,000. The cap for indemnity will be changed from $30 million to $50 million. We have covered over 99% of property transactions in Hong Kong. Latest figures show about 87% of property transactions do not have a transaction amount of over $10 million. That's why this cap has covered a lot of property transactions in Hong Kong. In 2022, we commissioned an actuarius to look into the situation as well as to take into account the affordability of the public. That's how we arrived at this figure. And under what circumstances may one apply for indemnity? There are 3 situations. 1, fraud. 2, misinformation or mistake by the land registrar. And if loss is caused to the applicant, then one may apply for indemnity. When there is fraud, when the former owner suffers losses, then he or she may apply for indemnity. If the court approves the rectification, the existing property owner may apply for indemnity. If the owner is a bona fide and there is valid consideration. In the following situations, property owner can apply for there are 3 situations in which property owners cannot obtain indemnity. 1, the property owner is involved in fraud, misinformation, or omission or incorrect information, where there is a lack of due diligence which may constitute fraud, omission, and mistake. If this is ruled by the court, then one doesn't have the right to apply for indemnity. In relation to the time bar of application for indemnity, the applicant must make a claim for indemnity within 6 years after knowing the existence of the claim. If the court has made a rectification order within 1 year, then the applicant will have to make a claim for indemnity. If the land registrar makes a rectification, however, we allow the applicant to make a rectification within 6 years. If the court has started a legal proceedings, we think the applicant may start an indemnity application about the determination of the amount of indemnity. Under the LTO, the date of the determination of the indemnity is based on the value of the interest and right on the entry on the date of fraud with a cap of $30 million. we have proposed to change the amount or to amend the amount with a court order or with a rectification order made by the court. We will base the amount on the value of the beneficent interest on the date when the court makes an order. Or if the mistake is rectified by the registrar, then we use that date as the basis. If none of these is applicable, then we take the date on which the indemnity application is made to determine the amount of the beneficent interest. Regarding protection of the indemnity fund, we have strengthened a few provisions in the hope of protecting the fund in the Land Titles Indemnity Fund. If the applicant has already received compensations before making a claim for the Land Titles Indemnity Fund, then such an amount approved must be deducted. That is to ensure applicants will not receive double compensation. There is also the right of subrogation, but it is only limited to indemnity fund or indemnity amount that has already been disbursed. We will also add new provisions to prevent double claim to be made by the same applicant on the very same incident. Now moving on to strengthening measures against property fraud. Point number 1, title certificate. In the bill, the registrar will send title certificates automatically to all property owners, whereas in the existing LTO, the registrar only sends title certificates when there is such an application made by the property owner. In the title certificate, we have also added features against fraud. In registration application, title certificates must be returned to the registrar for disposal. Only then will we accept applications. In relation to public access to record and connected matters in relation to documents, there will also be new provisions. Next, on the verification of application. Under the existing LTO, all matters need to be verified in accordance with the Land Titles Ordinance. All these should be conducted by lawyers. In the bill, we have added a new provision if lawyers have exercised due diligence and conducted verification, then they will not be held liable to any compensation or liability as a result of the losses. Next, in relation to restriction under the existing LTO, in relation to application made by interested person, the registrar can prohibit transactions in relation to land. And we have refined the provisions so that the provisions will target property fraud. If the registrar has reasonable grounds to believe that there is a property fraud, then the registrar can make a restriction to prevent any registration of the property. Thank you.
Under the LTO, an offense is made out. Anyone who fraudulently lodges an application for registration commits an offense. And under our proposal, we also have the new offense provision. For the same offense, we also introduced the same maximum penalty of $5 million and imprisonment for 14 years to achieve deterrence. Part 3 relates to amendments to the Land Registration Ordinance. We'd like to optimize the registration procedures. For example, we allow the submission of instruments electronically. We're also going to make regulations in relation to these matters. For straddling land and that no registration can be made, likewise, we have the relevant amendments as well. Part 4. Amendments to the Land Registry Trading Fund. That means we will amend Schedule 1 to spell out services to be provided under this trading fund so as to enforce provisions under the LTO and the LRO. That concludes my presentation, Chairman. Thank you, Registrar. The floor is now open. Let me read out the names of members, starting with Mr. Reverend Peter Kun, Lee Chen Kang, Tony Chair, Wendy Hong, Doreen Kong, Deputy Chair, Lo Wai Kok, Jimmy Ng, Maggie Chan, and myself. I will give each member 4 minutes question and answer. Let's start with Reverend Peter Kun. Thank you, Chair. 2 questions. First of all, I thank the administration for their efforts. I understand that this is a long-awaited bill. Now, they are going to implement the New Land First proposal, but as explained just now, the LTO was enacted in 2004. You will go ahead with New Land First. What about existing land? How much longer will owners have to wait? Would it be 2 decades? Do you have a timetable? The second point is about adverse possession. I think this is an issue close to the heart of many. So if the removal of adverse possession rule applies only to new land, would it apply to existing land as well? Because I think that many citizens will be concerned about the existing land being carved out of the mechanism. Secretary. Thank you, Chair. Indeed, we will start with property transactions on the new land after commencement of the bill as a start. And as mentioned, the Land Registry at the moment is conducting an internal research in relation to the registration of existing titles, including those with defects, the various types of defects, the number of defects, and then the Land Registry will analyze the situation and find solutions. So it is hoped that when this bill comes into operation in the first half of 2027, we will be able to float a proposal as to how existing land should be handled. So we are actively preparing for the regime for existing land, which will be floated in due course. As for adverse possession, we understand the strong calls from the community for this outdated arrangement of adverse possession to be repealed, and whether this adverse possession rule can be scrapped earlier. Now, of course, after introducing the title registration system, everything will be clear. All land parcels will come with clear boundaries, and there will not be the issue of adverse possession. As for existing land, we're actively exploring amendments to the limitation ordinance. We carry out this exercise so as to minimize the chance of a bona fide purchaser's rights being undermined because of adverse possession. However, under the existing deeds registration system, title certainty is not guaranteed. Although the deeds are registered and the names of owners seem to appear on the land register, there is no guarantee of title. So under such circumstances, those claiming adverse possession may have legitimate grounds in safeguarding their own rights and interests. So this system has been in place for many years. We need to explore the legal backing in introducing another system. Now, we've made reference to jurisdictions where adverse possession used to be practiced, and there are two ways of handling this arrangement. The first one is to repeal it altogether. The second approach is to provide guardrails so as to protect the interests of a bona fide purchaser. And in any way, we are not staying put. We are reviewing the existing legislation to see how adverse possession should be dealt with. Next, Mr. Michael Lee. Thank you, Chair. I support the government's efforts in introducing the new system for new land first in order to make an easy start. But I think a holistic view should be provided, and that means a blueprint and a roadmap should be provided as well. And I understand that the system will apply to new land first, and what about the automatic conversion mechanism? Will it cover redevelopments and URA properties so as to benefit more citizens? Because with simplified conveyancing procedures, members of the public would benefit from lower fees for their solicitors. So this will have a major impact on the general public. My question is about public education. It's such a complex bill. What will the government do to make the bill more accessible to the general public, including as well as the sectors? Because as I understand, in signing the provisional purchase and sale agreements, the consent caution documents may be signed as well. So my question is on the government's public education and publicity efforts. I will give the floor to the registrar to explain the nitty-gritty, but in terms of roadmap, we do have a clear timetable. The bill will come into operation in the first half of 2027. And as I said, for existing land, after the implementation of the new land first proposal in the first half of 2027, another proposal will be floated to cover existing land. So that means existing owners won't need to wait long. Now, which approach should we take for existing land? Should there be an automatic conversion, or should conversion be conducted only by application? We are exploring different options, and we aim at floating this proposal within 2027. Registrar. We attach great importance to public education and publicity. This is a major overhaul of the land titles registration system. So we have two strategies. We will raise the awareness of the sectors as well as general public's awareness. In fact, we've set up an advisory committee comprising stakeholders as members, and we had a meeting in January. We discussed our way forward on enhancing public education. We need to publicize the new system to different sectors as well, such as legal profession, banking, property development, etc. So we have sector-specific publicity campaigns. In fact, after floating this bill, we have held 2 briefing sessions, and in one of them, over 200 stakeholders attended. We also briefed the legal professional bodies. We need to start now. And we will continue to issue publicity materials and hold workshops. As for the general public, we need to explain to them the difference between the new system and the old one, and we also need to explain, for example, the rate of levy to be charged. That means we'll work with stakeholders. We will publicize the system to potential property owners. We take a soft approach to enhance the public's understanding of the land title registration system. Well, it is a challenge for us, but we will make sure that this idea is instilled in the minds of many. Right. I hope that templates will be provided in terms of registration of instruments. And please do share with us any template you've prepared. Right, I see in the PowerPoint presentation some templates are available. Next, Mr. Tony J. Thank you, Chairman. Well, this is a very important bill. We have many property owners in Hong Kong, and we're all concerned about improving the current registration system. As a member of this council, I will do my utmost to complete scrutiny of the bill. But let me remind the administration to do more, because we only received the relevant papers yesterday at 4:30, and we have the morning meeting today. And we are subject to a lot of pressure, because at the same time we're also going through the government's estimates. So I hope that this will not be a standing practice. Chairman, coming back to my point, many of us have waited for over 20 years. I remember that I was chair of the Hong Kong Institute of Surveyors, and I was consulted. I understand that there were diverse views from different sectors. Some were in favor of an automatic conversion approach. So I support the administration's efforts in tackling the EC bids first. That means the New Land First proposal. For transactions on new land, you will move away from the deeds registration and switch to title registration. You will also tackle the issue of adverse possession. Now I have 2 follow-up questions. The first is on the indemnity fund and levy and their relevant caps. In 2004, the cap proposed was $30 million. Now it's $50 million. Can you explain the change? When it comes to property value, have things changed since 2004? Property prices have come down, but if you consider 2004 as the baseline, then by 2023, property prices have gone up by 200%. So there is also a cap on levy, and it is formulated on a basis of $50 million of property. So since you've engaged an actuarial consultant, you should adopt the same formula for the calculation of the amount of indemnity as well. The second question is that according to the bill, where there is reasonable suspicion that a property may be assigned due to fraudulent grounds, the registrar will be empowered to impose a restriction order to restrict the transaction. So, registrar, perhaps you can explain to us how what it means by having reasonable suspicion, and what is your power in making this restriction order.
Secretary, thank you. Regarding the first question about the cap of $50 million, I will give the floor to the DS to answer your question. Next, in relation to reasonable suspicion, I'll give the floor to the registrar. Thank you. PS. Thank you, Chairman. As Mr. Toniche said, in 2004, we set the cap at $30 million. It could cover 99% of properties. We used it as the reference or the indicator. Now we have revised the figures based on the 2023-24. If we increase the indemnity amount to $50 million, we can cover 99% of all the property in Hong Kong. In relation to the levy, if it is to be increased, can we increase the levy the indemnity amount as well? In theory, yes, but we actually need to take into account a basket of factors. If we increase the amount of levy, it will increase the burden of property buyers. 0.014%. If this percentage can cover 99% of all the property transactions in Hong Kong, we find this percentage appropriate. Thank you. Any follow-up? Yes, please. Thank you. 99% of all the transactions, well, it was about the situation in 2003 to 04. Property values were taken into account. Probably you took into account not just residential property, you also took into account industrial property, factories, and so on. Can you supplement? PS. Well, after the meeting, we can provide written replies on what type of property is covered when we talk about 99%. Registrar. Well, in relation to restriction order, we took into account the circumstances we have at the time of handling registration applications. Usually when we suspect a fraud, the police force helps us with investigation. They obtain documents from us. Sometimes when lawyers are handling conveyancing cases, when they have reasonable grounds to believe there is fraud, they will also let us know. When some documents are suspicious, if the land interest is registrable interest, then we will maintain liaison with the police. Then the police will apply for a warrant from the court until the police can obtain papers or documents. This is the ideal process, but it takes time. As we can see It takes time for the police to do so. We seek advice from the police as to how we should proceed with these cases. If we don't want buyers to suffer losses, should we have the power to do so? Well, we will apply for a restriction order. We will talk to the police. We seek advice from the police. When the police receives documents, only after that will we step in and continue to handle the procedures. In other jurisdictions, there are similar powers, but we use these powers with great caution. We work with the police at the same time. Mr. Tonite, well, this is a very important document, so I hope there will be clear guidelines given to staff members. Otherwise, when the registrar is kept in the dark without exercising any power, this will create an undesirable impact. Thank you. Next member, Dr. Wendy Hong. Thank you, Chairman. The legislative amendment we're talking about today is very important. It's about the Land Registration Ordinance, which came into effect in 1844, as well as the Land Registration Ordinance. I believe we need to adopt a dual-track approach. This is a more practical method. Is it possible every time when there is a transaction of property, we go by the new method? If it doesn't involve new property or property disputes, actually it doesn't create much of an impact. The administration said that internal studies had already been started. There are many land title issues. As their paper said, verification procedures aren't comprehensive. I'd like to ask about the scale and the direction of future verifications. There are a total of 290 such verification procedures. It will require a large amount of manpower. So how are you going to cope? Some people are concerned about the indemnity fund rate of 0.014%. Fluctuations in property prices will have an impact on the amount. $150 million are set aside for the indemnity fund. Is it possible to have a standby loan facility? Will it be adjusted with the fluctuations of property prices to ensure there was sufficient balance in the fund? Earlier on, I suggest that the administration should use block tag, that is the core technology on the real estate market, to submit land registration. There should be concessions about levy rate to encourage the use of new registration method. There is no mention of what method to be used in the paper. I'd like to know what the administration thinks. Will you adopt block tag? Secretary, regarding the last two questions, there are bound to be property prices in the future. What about the standby loan facility? What about the submission of documents? I will give the floor to the registrar in a moment. In relation to resolving simple issues before difficult ones, just now Dr. Wendy Hong talked about another method that is involuntary in phases at the same time. Dr. Wendy Hong mentioned 3 ways in total. When there's a new transaction, the land title ordinance will be used, and we will have to discuss with stakeholders. In relation to preparations we are working on, we are conducting analyses. And I have to emphasize these are internal analyses undertaken by the administration internally. After we have conducted analyses, we will discuss with stakeholders. Property registration requires verification, and this is yet another issue. Now we are laying the groundwork. So within the government, we are conducting internal analyses as well as verification. So we don't look into each and every deed, that is the 2.9 million deeds. We use different technologies to conduct preliminary analyses, and I will give the floor to the registrar. Thank you. Regarding the use of technology, as I said in my PowerPoint presentation, when the new system comes into operation, we will adopt a system to receive electronic submission of applications. We will accept the electronic submission of documents. There are 2 systems in total. Regarding digitalization at the land registry, we are promoting the use of technology as well. Actually, all the records within the registry have been digitalized, and we will accept electronic registration in the future with the use of technologies. Dr. Wendy Hong asked a question about the use of technology, and it concerns the entire process. Say we use a digital platform to handle conveyancing matters. It has to do with the operation of the market. That is whether frontline practitioners will accept the use of technology, say e-signature, e-verification, e-registration, and so on. It depends whether the public or stakeholders will accept the use of digitalized method. From our perspective, we accept the use of technology, and we will also take into account the overall market development. The e-system will enable us to go digital internally. We have a keen interest in using new technologies as well. Regarding title certificates, we will launch a verification service to verify such title certificates. We want to make it convenient for frontline practitioners, not least lawyers. They can go to the back end of the system, of the online system, to check the authenticity of the title certificates. They can check whether the certificates are valid or not. We'll store the information in a shared blockchain platform, we can put this to test. Just now, the Secretary talked about in existing title register, there are problematic deeds. We do want to adopt technology as well. We are in talks with a few companies to make use of AI and OCR to expedite the handling of such matters. The business logic behind land record is very complicated. We may try to use AI. We don't aim to cover all 2.9 million problematic deeds. On the one hand, we are discussing with technology companies. On the other hand, we may also see which areas sees the most problematic deeds and how they arose, as well as where they are concentrated in. That's how we can devise strategies to implement the system. Thank you.
胡主席。
Next, Ms. Doreen Kong, Deputy Chair. Thank you, Chairman. I strongly support this New Land First proposal. I'm a conveyancing lawyer. When I was a solicitor trainee, I first learned about this new system, and Mr. Eric Lee was in fact my workmate. So it's really deja vu that we're meeting again here. I strongly support the New Land First proposal because I can see that the government is committed to tackling this challenge. We need to grab the low-hanging fruit first, otherwise it will be difficult to implement the system for both new and existing land. And after introducing the New Land First proposal, Hong Kong will rank higher in terms of competitiveness. Now, coming back to the indemnity fund, inevitably we take a user pay principle. My question is this: for property developed on new land, in the future, a levy will be imposed on assignments of the properties. So if I were an owner of this property built on new land, I would have this question. It is supposed to be a more advanced system, and yet I'm now required to pay an extra levy. Why should I be penalized? How are you going to convince new property owners that they are required to pay a levy despite taking this New Land First proposal? As for the indemnity cap, I understand that the cap will go up from $30 to $50 million. In theory, property prices should continue to go up. Is there a review mechanism? You start with a $50 million cap for the value of properties, but will you consider putting in place a review mechanism to raise the cap and enhance protection for buyers? Now, at the current level of $50 million, say if I am a potential buyer and I want to buy a commercial property which is worth $100 million, then I do want to have more protection. I may be buying adjoining units. Is it possible that I break down this transaction into several smaller ones so as to enjoy a cap for each and every transaction? My next question is for the land registrar. when we check the title documents under the present system, we're able to check each and every change in title ownership. In the future, if we do a land search, will we still be able to have access to this information? Right, 3 questions. I will take the first one as to the merits of the new land first approach, especially for new owners. And then the PS can take the question on levy. Registrar can take the last question. Now, after introducing the title registration system for new land, we can categorically tell any new buyer that they enjoy title certainty, and that's the number 1 merit. The number 2 merit is that it saves a lot of time in the conveyancing procedures. There is no need for a solicitor to go through the historical title documents. These are some major advantages. Now, the next question relates to the levy. Why should a new buyer pay the levy? I need to explain that the advantage lies in title protection. If there is an innocent former owner involved in a fraudulent situation, at present, only civil claims are allowed. The matter can only be resolved through a civil claim. After putting in place this system, an innocent former owner will be given the avenue of an indemnity. The system protects the new owner. So instead of allowing a civil claim, the innocent former owner will be allowed indemnity instead. We've made reference to the practice in other jurisdictions. Now, this point may not be easy to understand, but we need to make the other point stand out. It's very apparent, and that is you'll be able to save time and cost in the conveyancing process. I'll ask the PS to take the next question about a review mechanism for the indemnity cap. I believe that this cap will be subject to regular reviews in the future. According to the amendment bill, the Financial Secretary may, by publishing a notice in the Gazette, amend the indemnity cap. This will be done by way of negative vetting. So a simplified mechanism is available for revising the cap. But I'd like to supplement the answer just now. 99% of properties will be covered if we impose a $50 million cap, because the majority of property transactions are lower than the $10 million threshold. So that means 87% already covered. That's already a very high threshold. I'll give the floor to the registrar. What will the land search reflect in the future? I think your question provides the answer itself. Under the current deeds registration system, all the historical titles will be provided. So you can look at the history of this property. You need to ascertain title by going through all the historical deeds and all the registered instruments. But under the title registration system, if you do a land search, title is already ascertained, and the land search will only show all entries that may affect the interest of the land. For example, there may be a mortgage fully paid up, and as such, this mortgage will no longer appear in the title register. It is an obsolete record. It will be stored back end. However, a lawyer will be able to have access to all the back end records. a lawyer will have access to all the records, entries, and instruments registered. So for whatever instruments, records available, they will be stored in the backend system. They are accessible and ready for inspection if necessary. Next, Dr. Wai Kwok. Thank you, Chair. I support the migration from a deeds registration system to a title registration system. I understand that there are merits, and according to the government, because of these merits, the LTO was enacted in 2004. However, despite the enactment as early as 2004, it has not been enforced. This is peculiar. In any case, now we're taking a more pragmatic approach, and I appreciate that. My question is about application of the bill to new land only. Change of title ownership on existing land and the assignments thereof do not apply. Has it to do with your workload? Can you explain the estimated workload? Because you referred to some 2.9 million deeds, but the assignment of all these deeds will not take place at once. So the increase in workload should be manageable. The government is proposing introducing the registration system to new land first, and then we will gauge the situation and further expand the scope. But my take is that you can estimate the workload at this very moment. Secretary, over the years we have been working with stakeholders, including the property sector, the banking sector. There is a consensus that taking it forward on existing land is difficult, especially because of the checking of deeds before any assignment takes place. For other jurisdictions, usually solicitors will go through the conveyancing procedures. They check the title ownership before assignment. However, as we discussed with our stakeholders over the years, which party should be responsible for checking the historical deeds? Should the government be responsible, or should the parties to the transaction be responsible? And we failed to reach a consensus on this point. As I emphasized, the government's land registry is conducting an internal research. That means we are trying to find out the problem through analysis. Now, for example, very often the problematic deed emerges in a property transaction in the new territories. So by analyzing the situation, we may be able to find out more about where these problematic transactions take place, whether it's concentrated in the new territories, and by then we can work out a proposal with stakeholders. We've failed to reach a consensus with stakeholders by and large because of the responsibility issue. Under this new proposal, we take the easy approach. There is an indemnity fund. Should there be any disputes involving property on the new land, then the indemnity mechanism kicks in. But we don't envisage a lot of disputes arising from property transactions on the new land because there would be few covered by the system. So with the indemnity fund, we are expected to allow the indemnity to be made out. But for land disputes on existing land, things are more complicated. We are reviewing the situation and we've undertaken to float the proposal by 2027.
Thank you. I'd like to follow up. For old land, for the assignment on old land, with the existing mechanism, title checking needs to be conducted before assignment is allowed. It may entail a lot of lawyers' fees and a lot of work has to be done by lawyers. This system is proven to be effective. Now, when we want to change the system, there shouldn't be a lot of additional workload. If the deeds registration system is problematic, it will make it impossible for assignment to be done. Well, it may sound reasonable. So why can't we keep tweaking the system? Well, just now the Secretary talked about certainty. Well, will you supplement, Secretary? Thank you. We are reviewing the land registration system and we will check the record of property transactions. We have already done our level best. We haven't identified any issues, and then the record will be passed on to the land registry for handling. The existing mechanism is that even when all of what I have mentioned have been done, when someone turns up and says that something is missing, it doesn't mean that that person has a land title. When a check has been done, we refer to the title register. So it is the most accurate, whatever industries the checker needs to be held accountable. Well, we need to get this right. Otherwise, it will be difficult for us to scrutinize the provisions one by one. Deeds without problems. I mean, there should be a lot of deeds without problems. Those with problems should be in the minority. Thank you. Next, Mr. Jimmy Ng. Thank you, Chairman. Many members of the public don't understand what it means to read a deed. For every single document, we need to read all of them. Some lawyers may have oversights in relation to assignment procedures. So one of the greatest expenses is insurance, and the maximum, land transactions, property transactions, the largest amount of compensations are about these transactions. We don't refer to the land register when we check who holds the title. Probate, land exchange, land assignment. There's a large stack of this record. Lawyers have to go through checks to check whether this record is accurate or not. Just now there were different suggestions about overhauling the system across the board. Of course, you can put in place a cutoff date. That is, beyond a certain date, no claims may be allowed. But if the property owner is an elderly person who has already emigrated, who has already left Hong Kong, but then when they return to Hong Kong, all of a sudden they find that they lose all houses they have. So what can they do? That's why I understand why the administration is being cautious. The administration will start with the new land first by adopting the new land first proposal. I agree with the administration. I support this proposal. Can the administration explain the land titles indemnity fund? If there is a court order, it may take years to finish a legal proceeding, and property prices may go up. In the case of any rectification made by the registrar, then the amount will be based on the date on which the mistake is rectified. Property prices may go up. I find it quite unreasonable. Registrar. If the registrar rectifies a mistake or omission, if someone suffers loss as a result, say maybe property, then there may be consideration. Should a current value be more accurate to reflect the loss instead of the replacement value? Well, I'm afraid the registrar has got me wrong. I mean, if a mistaken entry is rectified by the registrar, when I apply to have the mistake rectified by the registrar, if the registrar takes the initiative to rectify the mistake, say if I have already left Hong Kong, I'm in London, and 10 years later I come back, the registrar takes the initiative to rectify my mistake. So it is unreasonable to use the value a decade earlier on. A decade ago, it would be unreasonable to use this value. DOJ. Well, all people have access to the title register, so they don't know. It is impossible to say that they only know the register or the change in the register 10 years later. Well, do you mean I should check the register every day? Should all members of the public check the register every day? That is not fair to the public. In case of any change in titles, you send SMS or messages to the persons concerned. In case of any rectification, do you send messages to the person affected instead of having members of the public check the title register on a daily basis? When there is a rectification on the title register, we inform the persons involved. Do you mean you will consider informing the persons affected? Yes, thank you. Next, Ms. Maggie Chan. Thank you, Chairman. I support resolving the simple issues before difficult ones. In relation to whether old land should be applicable, I agree with what Mr. Jimmy Ng said. In the legal sector, insurance fees are very high. And this would cause a considerable impact on the legal sector. Well, I'd like to refer to page 15. If lawyers have exercised due diligence while checking the procedures, then the lawyers shouldn't be held accountable to any legal liability. I'm a lawyer myself. I believe, well, I understand why these words are here. Are there any yardsticks to determine if a lawyer has committed professional misconduct? There are no precedents. So what if someone uses a false identity card or a bogus identity card or a title certificate? If the particulars on the bogus title certificate match those on a real one, so is the lawyer acting in good faith with due diligence? In relation to the levy in relation to land titles indemnity fund under the new land trust proposal, is it payable by the buyers, or do they reach an agreement before that? Is it paid together with stamp duty? If the property transaction is cut off, can it be refunded? When a provisional purchase and sale agreement is entered into, and before the issuance of a caution and the completion of a property transaction, assuming there are two buyers, and one buyer is accusing the other buyer of fraud, will there be a restriction? Well, as you can see, this is a very complicated situation. Will it make it difficult for the administration? Property transactions come in different forms. Will it be uncertain to buyers?
My next question is about the restriction order. In the scenario of a fraudulent property transaction, you can turn to the police, and of course, the situation is easier to understand. In a more ambiguous situation, however, say there is an original owner and then the buyer sets him up so that the property transaction takes place against the will of the original original owner, and the element of fraud may be involved, and that the matter may be reported to the police. The police may ask the parties to take the civil avenue instead because it's a civil dispute. Under this new land first approach, it seems that you're passing the buck to the police. Now, from the police's perspective, this may be a civil dispute. But what happens if there is a mistaken entry or a restriction order is made? How should the matter be dealt with? Secretary. Ms. Chan asked about the nitty-gritty of property transactions, such as the party responsible for the levy and the situations of fraud. I'll see if the land registrar could take this question, and if need be, we can supplement the answer in writing. Now, about the solicitor's liability in the future, I need to explain this. Under the title registration system in the future, apparently there is a big difference in terms of what the solicitor needs to do. Apparently, the difference in the new system is that the solicitor will not be required to check the historical deeds. However, under the new system, the solicitor is still required to verify a number of things, such as the identity of the seller and the purchaser, and whether they are in fine fettle to proceed to the transactions, and whether the transaction is carried out by a legal entity and not a natural person. In the future, a good title is reflected in the title register. And that the title owner is as set out in the title register, not the one holding the title certificate. And this is something that the solicitor needs to verify. We will promulgate guidelines in the future. On the whole, there should not be a major difference in terms of what a solicitor should do. The only difference is that there is now a certificate of title, and I think that the details will be set out in the guidelines. I'll see if the land registrar could take the other question about the levy. Simply put, the purchaser should be responsible for the levy, and perhaps when the solicitor makes an application for title registration, the levy will be paid along with other fees, including stamp duty. Now, if for some reason this title cannot be registered, the levy will not be collected by the land registry. The member also referred to different scenarios. Perhaps we can explain in greater detail in writing. After signing the PSAP, a consent caution will be entered into, and there will be a postponement effect in this event. And that means there will be priority over this agreement. If another consent caution is submitted by another buyer, since the first buyer already has priority with that consent caution, then any instrument to be registered will have the postponement effect, and that the instruments so registered will only take effect after the transaction has taken place. So, as you mentioned, after registering a consent caution, another consent caution relating to the same transaction is submitted, then the latter should not enjoy priority. The member also asked about fraudulent transaction and the setup and how the restriction order should be made. We'll go back and provide a supplementary answer. Chairman, just to supplement, no matter the scenario, I'm concerned that the government may be passing the buck to the police, and the police are unable to address the situation, and in the end, there will be a legal vacuum. Next, Mr. Tang Fei. Thank you, Chairman. I strongly support this amendment bill. This matter hinges on the interests of the general public. The title registration system should be kept abreast with the times. We should stem out adverse possession as far as possible, and there should be measures to tackle fraudulent transactions. I appreciate the administration's proposal. Now, I'd like to speak from the public's perspective. In point E of the PowerPoint presentation, where the registrar have reasonable grounds to suspect that the property fraud has been or is about to be committed, then the registrar is empowered to make a restriction order prohibiting the registration of a disposition of a property. So a notice may be made through a solicitor's firm, through the police, or through the owner's own title checking activities. Now, in the Investors Education Committee, or the IFEC, provides ample information in these situations. There may be fraudulent activities in relation to the down payment or in relation to mortgage. So for the guidelines to be promoted, will you work with the IFEC to make sure that the information tally with each other? They already have very clear guidelines. Next, if the land registrar vets the title register and discovers frauds, and what should happen? That means not arising from a police complaint, but from the land registry's own activity. Will the police be informed? Will the notice be given that a restriction order will be made to prohibit any property transaction? Any party privy to the transaction will be alerted. According to the amendment bill, there is a very serious offense made out against a person who fraudulently lodges such an application, and that it comes with a maximum penalty of 14 years of imprisonment. So my question is about the land registry's own discovery. So that means definitely this offense is one of an indictable offense, a serious offense that attracts a 14 years of imprisonment and $5 million of fine. So like Ms. Maggie Chen said, different parties may be involved. One may be passing the buck to each other, from the police to the land registry, etc. I just want to know whether guidelines will be provided to educate investors and owners. Secretary, to take the first question, we need to take a comprehensive strategy in educating the public. And I thank the member for reminding us the work of the IFEC, and definitely this is one avenue for us. We'll definitely follow up on it. Next, about the registrar's own discovery. of suspicious cases and whether the police will be called, I'll give the floor to the registrar. Well, the answer is in the affirmative. This is also the case under the current system. Because of the title registration system, we have set up a mechanism with the police. That means under the bill, the registrar will be empowered to make a restriction order where there are reasonable grounds to suspect that a property has been or property fraud has been committed. So in terms of property fraud, the relevant trend and statistics, we share these details with the police. About the powers to be exercised by the land registrar, we will promulgate internal guidelines in due course. The modus operandi of property fraud change with time, so we need to catch up. We should not allow the lawyers, the police, and the land registry to pass the buck among each other. We should identify and read out problems together. We will exercise prudence in imposing the restriction order because if the transaction involves an innocent buyer, we need to be very careful in exercising this power. And this is what matters instead of just about the power for the registrar. We'll be very careful. Mr. Louis Long, I support the amendment bill. I'm the steering committee member since the first term. Mr. So Kai-long was the registrar, and since then there have been 5 successors. And then we have the incumbent here. The Land Titles Ordinance was enacted in 2004. When will we begin to see the benefit? Now we've reached the final furlong. I do hope that this system will be in full operation for new land by the first half of 2027. This is a practical compromise. Other members asked about the differential approach for new land and existing land. Over the years, as a steering committee member, I heard supporting and opposing views. I'd say that this is the practical compromise. And I support it. Well, I consider myself a midwife in this situation. I look forward to the delivery of this baby. I also hope that this baby will be in good health. And it's the responsibility of the Bills Committee to go through the nitty-gritty. In any way, having heard other members' views, I have one question. I fully appreciate the need for an indemnity fund. You've engaged an actuarial consultant. The policy objective is to cover 99% of all property transactions. I'd like to know more about the assumptions adopted in your model. Have you considered, for example, different types of property transactions? The majority of property transactions are residential properties. Commercial property transactions may be fewer in number, but the consideration may be much larger relative to that for property in the residential market. Have you set up different models for different types of properties? Because you've also proposed a levy. So would there be a tiered levy system for different types of properties to reassure the relevant parties to the transactions? Say for commercial properties, the parties may be covered by a higher indemnity cap. So that's my question.
Thank you, Mr. Leung. Secretary, we may provide written reply if Chairman agrees. We will provide information on the assumptions of the levy. What types of transactions have we looked into? We may provide a written reply. Quite many members asked about the levy. So, yes, you may provide a written reply. Thank you. Next, Dr. Junius Ho. Thank you, Chairman. There was consultation about this ordinance. This is a long-standing problem. We need to check titles in order to sort out the matters. In this process, a lot of problems arise. Among the 2.9 million deeds, not all of them are clean. It's impossible to migrate all of these deeds overnight. From the registration of titles to the new system, not just registration, verification also needs to be done. We need to simplify the system, not just about registration, but also about verification and so on. This is a long-standing problem as we cannot solve the problem overnight. Even if 99.9% of 2.9 million deeds are clean, the 0.1% is already worth our investigation. We need to see who will be held accountable. There is the pre-1997 situation. The Law Society of Hong Kong should be held responsible for it. It's a problem about negligence. Professional indemnity. This is a huge dispute. There is loss of titles when in the era of Japanese occupation, there are also matters in relation to Chotong land. There is fraud as well. After title registration, we cannot solve the problem. So in 2004, there was the land title ordinance. So all along, we couldn't solve the problem. When the title registration was passed, the ordinance couldn't be used to solve the practical problems. In 2004, there was a committee stage and some changes were proposed. So now, shouldn't we proceed with new land first? Is it good to resolve simple issues before the difficult ones? Now, it is like we are deceiving ourselves. We need to face the problem, to face the situation squarely. Probably less than 0.1% of the deeds are problematic. I'm no expert in conveyancing. I'm not a lawyer practicing in this area. Regarding the PIS, Professional Indemnity Society, well, Chairman, I want to set out the background first. Please give me a few more minutes. Well, this is a brave move, but you could be braver. You need to handle new land together with old land. The number of claims has to do with economic performance in Hong Kong, but in fact, the administration needs to shoulder the responsibility. Yes, this is correct. The levy needs to be increased. That is correct as well. There is a public indemnity fund to handle compensation in relation to hit-and-run cases. If we need to use the system, we need to work on new land and old land at the same time. Say you need to have a deadline for each applicant to make a claim. When you institute a proceeding, you need to have a time bar. Otherwise, the case will be put back to 2047. With title registration, property owners will conduct DD like a physical checkup. Say for listed companies, they check whether the assets still belong to the companies. That's exactly how we can prevent fraud. We have the title registration system, and well, Chairman, I'd like to say one sentence more. Well, minibus driver, taxi driver, bus driver, they don't register. Say when their wives purchase the property, the name of the driver isn't on the register. They couldn't enjoy the relief under common law. So the administration needs to take a braver move by covering both new land and old land. Well, Dr. Ho talked about his views on the implementation of the New Land First proposal. So, your take, Secretary? Well, Dr. Ho talked about taking a braver move by implementing the proposal on new land and old land at the same time. The administration needs to have a good understanding of the concerns of different stakeholders. We don't have a consensus yet in relation to the implementation of the proposal on old land. So we shouldn't be, we should proceed with the new land first in light of difficulties with old land. Old land shouldn't stand in our way. When we have implemented the new land first proposal, when we have sufficient experience, then these experience may help us in our future endeavors. Point taken, Dr. Ho. I understand you want us to be braver, but we do have pragmatic concerns in relation to the limitation ordinance, which has to do with adverse possession, we have made it very clear that the administration will actively look into amending the limitation ordinance to deal with all matters related to adverse possession. That doesn't only cover new land. With the implementation of the new land first proposal, there won't be any adverse possession in relation to new land. But wherever we're going to implement the proposal, we will see how we can better deal with the adverse possession matters. Well, I will have to extend the meeting by 15 minutes first. Before Mr. Porte speaks, I'd like to ask members whether we should invite the public to express their views. We can hold a public hearing, or we can invite the public to submit written submissions. Ms. Doreen Kong, while this ordinance is very important to all members of the public, let's hold a deputation hearing, but we should also allow the written submission of representations. This is part of public education. Any more reviews from members? Dr. Ho? I agree. It's necessary to hold the deputation hearing. Despite consultation, we do need to have a deputation hearing. Mr. Louis Long? Yes, I agree. It's good to have a public hearing with deputations. All right, the Secretariat will check the schedule of the rooms, then we'll inform members of the date of the public hearing with deputations. Details will also be uploaded on the website of the Legislative Council. The public will be invited to provide written submissions. District councils will also be invited. Thank you.
Mr. Porte, thank you for allowing me to speak first. I see two other members having indicated their wish to speak. I'll be brief. Chairman, having heard the comments made by other members, I feel that this committee supports the bill, but we have different views on the implementation details and timing. This is an opportunity hard to come by. If we take a look at footnote number 15, England and Wales, Scotland, Singapore are three jurisdictions that also practice common law. We used to adopt the same system, and it has taken a long time for other jurisdictions to implement a new system. And England and Wales actually introduced a system in 1925, and by now it only covered about 87%. Scotland, enactment in 1981, so far 55%, and Singapore took a quicker pace. Enactment took place in 1956. By 2017, the conversion rate was 99.9. So for England and Wales, 0.9% remaining, 1.27 for Scotland, and 1.63 for Singapore. That's the pace of conversion. So it's a once-in-a-century opportunity for us. I fully agree with Dr. Ho's point, and I also agree that we should start with the low-hanging fruit. But the first step for Hong Kong will only take place in 2027. That means it will take forever for the system to be fully converted. Now, for the land in the new territories, perhaps it's more difficult, but for recent developments in urban districts, surely it will take much shorter to register titles. Anyway, this is a major overhaul to our existing system. The scope of new land should be relaxed so that we can ride on this once-in-a-century opportunity and speed things up. The other point is this. We should allow voluntary registration or conversion for consideration. Owners should be allowed to opt for the title registration system so as to enjoy more protection. So, Secretary, as per the scope of new land and the exceptions, new land that have not been divided into undivided shares will be exempt, will not be covered by the scope of new land. But that's only a very small percentage. I think it's a waste of resources when you talked about internal research. You should leverage on market data. Like Mr. Jimmy Ng said, although it's not watertight, the risk is minimal after solicitors check all the documents. In urban districts, very often solicitors are required to go through each and every deed. It's like deed washing. Let me give you this example, Chairman. If we were to go through all the motions passed in the current or in the previous legislative terms, it's a time-wasting exercise requiring colossal effort. So it's a deed washing exercise that we have at the moment. Just like the example of motion I mentioned, I don't think we should spend excessive resources on deed washing. Considering the level of risk entailed, we are already lagging far behind. We need to catch up, and that means we need to quicken our pace. So that's the major point I'd like to make. The other point I'd like to make is to suggest the administration to suitably relax the scope of new land so as to speed things up. Secretary. First of all, I thank Mr. Paul Chair for citing the other jurisdictions, and that for these jurisdictions, they have also taken a lot of time in migrating to a new system, and yet it's not 100% migration. I want to reassure members that we are not just using other jurisdictions' experience as the benchmark. We will do more. That means after putting in place a new system, we can fare better than other jurisdictions. So that's basically the consensus, and that by 2027, on the basis of this consensus, we will float another proposal, and hopefully this will speed things up. To answer the member's question, is it possible that we make use of this opportunity and widen the scope of new land? For land lease granted on or after the passage of the bill or commencement date of the bill, that's the criterion to be adopted. Now, members have suggested moving this forward even before the commencement date of the bill. Is it possible to include, for example, properties that have not been divided into undivided shares, specifically properties not yet sold, in other words? Very often, if the title has not been divided into undivided shares, or if the flats have not been sold, if it's still at the construction stage, other parties may already have been involved, say the mortgagor and other parties. So if we are to include these properties in the new land first approach, things will be more complicated. The proposal is floated on the basis of consensus reached with stakeholders. It has taken time to forge this consensus. We don't want to have another round of the same exercise because this will push things back. by 2027, we will be able to come up with options on how existing land should be dealt with. And perhaps, again, we'll go for the low-hanging fruit first. I don't think we should stay put and be stuck on the same issue. Ms. Carmen Khan. I've heard the comments made by my fellow professionals in the legal sector, and I do agree that this has remained a problem for many years. As I said during the panel meeting, as a trainee solicitor trainee, I did not choose to go down the path of conveyancing exactly because of the painful process. So instead of conveyancing, joining the conveyancing field, I worked for a bank. Anyway, I'll leave the matter to the conveyancing lawyers here. I want to raise another question. I really appreciate the administration's commitment in solving problems. There are always more solutions to problems themselves. Taking this New Land First proposal, as we know, not many government leases have been granted. And after granting a lease, you need a developer to take forward the project. Then comes construction. It will take a lot of time. So, like the other member said, you should consider a parallel approach. While Dr. Low represents his sector, perhaps we can all think about the possibility of a dual or parallel system. Say, the land has been granted and flats have not been sold by the developer. There may be other issues for the developer to take a building mortgage. Perhaps at that stage, the land has not been divided into undivided shares. There must be some arrangements that can be put in place so that we see light at the end of the tunnel about introducing title registration for existing land as well. I find it hard to palate for the administration to float the proposal only in 2027. Although you tell me that you have started making preparations, don't tell me that we should take things one step at a time. I think the step is too small. We've waited for decades. We have lawyers here. We also have property developers here. Don't cite stakeholders' views. They have conflicts of interest. They must submit views in their own favor. So from the perspective of the government, you should go ahead with what you plan to do. Because if you ask a lawyer or if you ask the solicitor firms, they may not be 100% supportive. In fact, in other jurisdictions, they form committees. They engage retired lawyers. They take a more neutral approach in vetting the proposal. You need to make a fresh start, albeit a very difficult one. What about the voluntary arrangement? Is it possible to have different tiers of levy? Please draw up more options. Secretary. Thank you, Ms. Khan, for explaining her expectations on us. To give a very brief response, why is it that we are reluctant to widen the scope of new land at this stage? We don't want to make a big compromise just for the sake of a minor relaxation. As set out in the paper, If we introduce the new land approach and the new land first proposal at this stage, in the coming 5 years, according to our estimate, we should be able to process 25,000 title registrations. If we consider land sold by the government in the past few years, as well as land that have not been divided into undivided shares, then I can conclude that there aren't many such cases. According to our analysis, the risk is low, and therefore there is no ground for us to start another round of consultation with stakeholders and for the Department of Justice to draw up this bill again. We are very concerned that we may not be quickening the pace, but slowing down instead. We should go by the new land first proposal at this stage, and in 2027 we'll be able to float a new proposal. So I would implore members to give us time for us to catch up, so that we won't be sacrificing more for the sake of taking a small step now. Well, I think the administration is taking the same approach, the same attitude. They are just dragging on their feet. By 2027, the next term of administration will come into office. Does it mean that you'll be dragging this problem on forever? Because you have 2.9 million registered deeds in Hong Kong. I really don't see any resolve on the part of the government. This is just the bare minimum. I'm sorry, I can't phrase it in Chinese. I see no surprise, no excitement. It's just a bare minimum. The sector is disappointed even. Well, I'm going to speak for the first round, and that two other members will speak for the second round. I will extend the meeting by another 15 minutes. So now it's my turn. I support the government in going for the low-hanging fruit first before tackling thorny issues later. Do you have resolve in tackling thorny issues? Well, definitely we should take one step at a time. In 2022, when you consulted the panel on development, I already raised this question. Is it possible to have a voluntary registration mechanism? Is it possible for me as an owner to engage a lawyer to go through all the instruments so as to minimize the risks? It's been 3 years since 2022, and there is no guarantee because the proposal for existing land won't be floated until 2027. So I'd like the administration to explain their approach, whether this is too slow, and that this issue, after all, is something that we are very concerned about. And as explained by the registrar or the secretary, an internal review is at the moment being conducted, and at a glance, there seems to be several thousand title defects identified. So how many titles have you gone through? Because as you mentioned, there are 2.9 million titles. It will be a lengthy process to go through each and every of them. So in the end of the day, you will have to rely on market forces. You need to engage professionals in the private sector. They are ready to chip in now. So I think we should set a deadline. For example, 5 years after passage of the bill, you should mandate owners to check their title, for example, as part of their responsibility. Do you think that this will improve your proposal? Another point is that we envisage passage of the bill within this year, and following that you'll make a subsidiary legislation. So we still have roughly a year or so before the bill comes into full operation. So within this period of 1.5 years, for example, can we allow new developments in the private market to be covered as well on a pilot basis and not wait until 2027, because people will be familiar with the new approach anyway. And you can also apply the relevant rules for new grants, land exchange, etc. Secretary, how about allowing these new developments to be covered on a pilot basis? Because 25,000 registered titles in a period of 5 years. That's a drop in the ocean comparing to 2.9 million titles in Hong Kong. We're concerned that it will take a lot of time to go through 2.9 million titles.
其實
Thank you. When we take the easiest bit first before moving on to the difficult ones, well, we will make proposals in 2027. The Land Registry is conducting analyses, and in a moment I will give the floor to the registrar to give us more information. She'll be sharing with us what they have looked into. Now we have started analyzing the situation. Next year, we'll be able to let the public know what we think. We may give an account of the analyses to the panel. We don't have to wait until 2027. Before that, members will hear from us about the outcomes of the analyses. Next year, when it's appropriate, we will share with members. But I'll give the floor to the registrar to tell members about the analyses. Thank you. Just now we talked about analyses about the 5-year land policies. Just recently, we looked into 10,000 cases. We identify any register with problems using our computer system. There are some 8,000 problematic cases. We have manually checked 10,000 or so cases. We did so one by one. We identified some registers with problems. 70% of these cases were dated back to 1980s. About 75% were dated back to 1950s. 1950s, 7.5%, 1960s, 7.8%, 1970s, 3.8%, 1980%, 2.1%, 1990s, 2.1%. After the year 2000, similar percentage of cases. In the new territories, about 99% of the cases are problematic. That's the figures we have so far. In the urban areas, there are scattered cases. Most of these cases come from other lots. When one lot has a problem, then many units on the same lot will also be problematic. And we are conducting analyses of this phenomenon. We have a very small sample size, and it will do more work to ascertain our findings or understanding of the situation. Starting from 2027, we will put in place the new land first proposal. Say 20 years ago. I mean, let's cover land that is approved 2 decades ago. Then it will cover 20% of the total number of lands covered in the title register or the land register. As the register has already gone digital recently, it will be easier for us to conduct a search. And the rate of problematic cases has gone down. If we conduct more checks to validate or to verify what we think, we may be able to do so. I hope members will give us more time and we will see how we can quicken the pace with the verification work. In due course, we'll share with members. I thank the Secretary for the undertaking and the Registrar for the explanation. After year 2000, for the land approved after year 2000, we may look into these cases one by one or in phases. The LRC in the 2014 talked about the amendments to the relevant ordinances. The notification system, we won't have it anymore, as there won't be any reverse possession with the implementation of the system. Just now, the Secretary said, no matter what, you will amend the limitation ordinance in the new territories. After the rights have changed, such as the right of possession and so on, it gives rise to many legal vacuums, so to speak. So I hope we can plug the loopholes. We can fill these vacuums. So in the new territories, when we're going to have more developments in the area, I hope the problems can be solved with short-term waiver. I've extended the meeting to 11 o'clock, so 2 minutes max for Mr. Ring Kong and Dr. Ho. Afterwards, we'll wrap up the meeting today. Mr. Ring Kong, thank you. Members talked about implementing the system on other pieces of land in an orderly manner. I'm not against it. I've been on the Land Registry Steering Committee for a long time. It's very difficult to sum up the difficulties. Say the impact on the indemnity fund, liability of lawyers, interests and rights of members of the public. There have been very long meetings. We have taken those into account. So the new land first proposal, we may start with this first, and then we can see how to proceed with other pieces of land. This is quite a good suggestion. Afterwards, we may see a glimmer of hope. We will also know whether the public accepts it or not. If we implement the proposal in haste, no one can shoulder the responsibility if things go wrong. I've been working in this area for a long time. In the market, we don't have a lot of lawyers who can examine the deeds. So I believe there are many complicated issues in taking this forward. It doesn't mean that we shouldn't advance, but there should be room given to us to plan well. I hope the administration will go back and think about this. In relation to levy, is it possible to allow exemptions, say intragroup transfer of probate? Is it possible to have exemptions? The administration may consider what Mr. Ren Kong said and will may the administration please reply at the next meeting. For ex gratia allowance resumption of land in the new territories, I even had to invoke laws of the Qing dynasty. So probably we'll have to solve the problems using indemnity. It's not without risks. I understand it's no easy task. But today we've heard from the administration that we have struck a balance. At least we know the direction of how we are going to advance. This is important. Thank you, Dr. Ho.
Thank you. Well, Chairman is not a lawyer, but he has vast experience in this area. Now, Secretary, today marks the first step. In 2004, LTO was enacted. That was the second step. So pre-1997 was the first step, 2004 LTO, the second step, 2025, that's the third step. We need to take the fourth step. I was a council member of Law Society. When I left in 2017, well, that piece of legislation, the name of which I cannot remember, well, it's in fact the LTO, Land Titles Ordinance, was gazetted in 2004. But if you go to e-legislation, the bilingual website, you find that this ordinance is not in operation despite being enacted in 2004. When I left the Council of Law Society in 2017, internally we were examining the 17th or the 18th draft. It has the ER5, ER6 amendment. So, members, we are seeing this amendment on top of the previous amendments. This ordinance has not yet come into operation. So you talk about going for the low-hanging fruit first, but in fact you haven't dealt with all the issues. At present, there are some 8,000 title defect cases for titles in 1950s. They account for about 75%. So the remainder is not large in number. We should show some resolve. The LTO is actually shelved because nobody wants to take responsibility. So who should take responsibility now? I think the real solution is easy. We should go ahead with the proposed indemnity fund. We should charge levy. The government should take some responsibility. And meanwhile, we should still allow the legal avenue for some owners to make a claim against those who undermine their interests, because we have 99.9% of good titles, and we should share responsibility together. Owners should also fulfill their responsibility. They should check that their titles are good. I just want to make sure that the communal avenue should remain available. Well, I think we have various suggestions for the administration to consider. I mentioned, for example, the time bar for making a claim. Perhaps we can have an answer at the next meeting. We should wrap up discussion here. The next meeting should be held at 10:45 on the 5th of on a Friday. And I think we've had a very thorough discussion. I hope that next time on the 2nd of May, we can then move on to a clause-by-clause scrutiny. So meeting's adjourned now.